Okay, so Nina, please carry on.
To 350. All right. So, welcome back. Sean, I just wanted to ask another question, if we could, before we turn it over to the audience. So, we're going to ask what lessons, if any, can we glean from the cases where the Westway Bill has been enforced? And then if you get a chance, maybe we can talk a little bit about how the Westway Bill functions with the provincial health and safety regulations as well.
Okay. I think fundamentally, and you're all going to think it's terrible that I'm so trite and obvious in saying this, it's going to be a rare thing that there's going to be a prosecution under C-45. I say that especially recognizing my own context as a prosecutor in the province of Manitoba. I'm going to suggest to you that it's only going to be in a factually very, very serious set of circumstances, and it's only going to be contemplated at this point where there are very significant consequences. And I feel stupid even saying that because it's so obvious, but in Manitoba, just to build on that, in the 12 years I've been in the unit, and I grew up in Manitoba with the exception of the time I put in law school. I'm only aware of one incident that claimed multiple lives, and it was a two-person fatality at Canamara Foods in Altona, Manitoba. I was counsel to the inquiry after the Federal Prosecution Service lost their prosecution on the grounds of jurisdiction. I'm also going to suggest to you that it's going to be very unlikely to, in the short term, lead to dispositions of jail. As a prosecutor, both on the front lines of criminal prosecution and even more so in terms of my work in the Provincial Statutes Unit, in Manitoba, frankly, you have to work pretty hard to go to jail. Especially if you're going to be doing provincial offenses. Provincial offenses that attract jail in Manitoba really bear a very strong resemblance to true crime. For example, we've sought jail on animal care cases where it looks a lot like animal cruelty. That's another obvious comparable. We have received jail in the trafficking of contraband tobacco, which obviously looks like possession cases and trafficking and smuggling and all of those kinds of heads. I think that another lesson to be learned is that for this bill to be implemented to the degree wished by those of us in this room, there's going to have to be a significant infusion of resources into prosecutorial specialization and police specialization as well. In Manitoba, like I said, I'm very fortunate to work with a group of dedicated and highly trained safety and health investigators, and it's a special investigations unit within the branch. So I'm really very fortunate in terms of the quality of the submissions that I get. We're going to have to continue to improve regulatory liability and continue the fight on the provincial statute side as well. We're going to have to continue to improve inspections and administrative penalties and show the courts that we are using prosecution as a remedy of last resort and that a significant amount of the work that we're doing is extrajudicial. In terms of how C-45 functions alongside provincial legislation, I made the point earlier that I receive almost nothing directly from police. In fact, I've received, I think, 2 ever asking for criminal charges, one of which is currently on my desk, and the police report was lacking in detail to the point where I've declined to even look at it until I've received the report of workplace safety and health. I didn't want to refuse the case, and I didn't feel I would have had much of an alternative if I'd taken and applied the prosecutorial standards on what was submitted to me. I know there are two. I'm just trying to get clear in my mind which the two were. Right. So the second one, it's going to end up being a provincial prosecution. It's going to be a new area of prosecution. It's going to be under a provision where employers owe a duty to other persons and not just to employees. And that's going to be a significant advancement, we hope, in the jurisprudence in our province. I think the most important thing about the way the two pieces of legislation, that is C-45 and the Provincial Workplace Safety and Health Act, work together is it provides a further option or opportunity for Crowns to consider. I think that Professor Glasbeek was correct in as much as he indicated that defense may always perceive an advantage to trying to deal with provincial legislation rather than criminal legislation. I think that has to, well, it's clear right now as the law stands that that probably has more to do with stigma and the fact of a criminal record than the pecuniary penalty. I don't agree that prosecutors would horse trade those kinds of charges away willy-nilly. While workers may have to work under a great deal of policy, I can assure you that so do Crowns, and there are a number of very specific policies that not only policies but professional obligations that lawyers in Her Majesty's service have to the Law Society of Manitoba that we zealously advocate our cases. And I would suggest to you that if there's a reasonable likelihood of conviction and a perception by the Crown that it's in a public interest to proceed, those cases would not simply be horse traded. I think that when I talked about the challenges for Crowns, and speaking again from a Manitoba perspective, there are a lot of challenges that we face. There are 120 some of us. Delay and workload are ongoing issues, but I can tell you that with the Crowns that I've met and worked with over the years, among the challenges that we have, I've alluded to, sucking and being gutless are not among the challenges that we have. I would suggest that the most important concept in terms of succeeding under C-45 is to build a strong foundation of prosecutions under the provincial legislation. One of the questions I had at the break, and maybe we'll get a little later for the whole room, talked about the importance of a collaborative kind of mens rea that we would be looking at under a C-45 prosecution. And when we look at the fact that there hasn't been a wealth of jurisprudence in the area, I think the judges are going to look to what they're accustomed to looking at. And what they're accustomed to looking at is a due diligence analysis. And that, by the way the courts have interpreted it and given it to us, is going to move us in the direction of looking to a corporate or community kind of mens rea that the court will be able to hang its hat on when it's asked to adjudicate a case under C-45 instead of the imposition of fine as in Metron.
Great, thanks. So I know that there's some comments at the front table here with respect to those issues as well, but just in the interest of time, I'm wondering if we should open it up to questions right now. Yeah, go ahead.
Greg Yost of Federal Justice. For 17 years, I was part of Manitoba Justice before I went to the dark side and came to Ottawa. So I know some of the challenges you were dealing with then and you're still dealing with now. But I'd like you to comment, if possible, on a couple of things. By the way, one of my other files is impaired driving here in Ottawa. So we started with criminal negligence in causing death and using that in driving offenses. We brought in dangerous driving and dangerous causing death. I want to know whether you think the different mens rea, wanton and reckless disregard versus what's defined as a marked departure, would make much difference in bringing C-45 prosecutions. That's my first question. Secondly, in your cases you've dealt with, have we been dealing only with deciding whether to go after the corporation, or have there been individuals charged with criminal negligence causing death, sort of using the C-45 duty of care. That's it.
Well, in terms of wanton or recklessness versus marked departure, of course, you recognize you're asking me a hypothetical, and I have nothing on which to base my answer. I have never conducted a C-45 prosecution, obviously. I don't see a distinction in terms of proving it. I think that the idea of a separate, somehow lesser criminal offense is probably not necessarily going to be helpful. I think that really when you're starting to talk about telling someone that they're so offside in their actions in society that society regards them as criminal, I think that is going to be the chief stumbling block to having someone accept responsibility. I don't think it's going to matter if it's wanton or recklessness versus marked departure. Frankly, with the cases that I see and the incredible work that goes into establishing industry standard, I would be more comfortable personally prosecuting a marked departure case than I would a wanton or reckless standard. That's just off the top of my head. In terms of individuals, there was one case where an individual was convicted under the Workplace Safety and Health Act. It was a case where I did make a representation within my own office that C-45, well, it wouldn't have been C-45, but that criminal negligence be considered, and it just so happened that it was an individual in that case, and the decision was made above my pay grade that that wasn't to be.
Go.
Jean-Guy Bourgeois from the Manitoba Federation of Labor and a member of United Steelworkers. My question is for Sean Brennan. It relates to a comment I believe you made early in the panel about opting between pursuing a prosecution under the Provincial Workplace Safety and Health Act or under the C-45 criminal code provisions. And at the Westray Law Symposium last year, we heard that it's not necessarily a choice, an either or kind of choice. And in some cases, it might even be advisable to go under both. Just wondering if you could comment on whether that's true on the either or issue and on the advisability of going under both.
It seems to me that when I draft an information under the Safety and Health Act, you're going to see something in the neighborhood of 1.5 to 2 dozen charges, depending on the heads of negligence that I'm dealing with. I draft informations to win and to make sure that I'm going to have something at the end of the day. It seems to me that as a belt and suspenders kind of Crown attorney, that you would go with both. I don't see it as an either or kind of choice. And there are other examples where people can be prosecuted under both federal, albeit not often criminal code, and provincial statute at the same time. And other than the judges tipping their hat to the sentencing provision of totality, I don't see an impediment. It has been held, I will stand to be corrected, but it has been held that it is not kine-appled when it's a provincial statute versus federal.
Great. Any other questions? Okay.
Robert Champagne from the Steelworkers. I just wanted to take up a point that Corey made about how difficult it is to assess why Westray isn't working, because Crowns don't really ever have to tell us why they don't pursue cases. And I'd just like to give you some insight that flows from the Steelworkers private prosecution of Weyerhaeuser that I was engaged in. The Steelworkers pursued a private prosecution of Weyerhaeuser because a steelworker member, Lyle Hewer, died in a machine called a hog at a paper mill, which is used to, the hog is used to crush waste wood. And we know a little bit in this case about why the Crown didn't pursue the Hewer case in the Weyerhaeuser prosecution, because after not providing reasons a number of times, and at the request of both the widow and the steelworkers, after our private prosecution was stayed, the Crown did actually issue a statement, a 3-page statement, which provides some insight into the Crown's thinking about why they didn't proceed. And in that case, they said that the legal duty in 217.1 wasn't breached, and that's the duty to take reasonable steps to prevent bodily harm. And the reason that they didn't find that the duty had been breached was because the employer didn't know that employees at this sawmill were getting into the hog to unclog it. That was the reason. And as a result, they weren't under any obligation to take any reasonable steps to prevent people from doing so because they didn't know what was happening. The evidence suggested otherwise, although not accepted by the Crown, the evidence that came from the Workers' Compensation Board who investigated, and the evidence that was put in front of the provincial court judge by the steelworkers during the private prosecution it attempted. But whether or not you believe that the company knew, there was certainly ample evidence to conclude that the company ought to have known on the evidence that this was happening. And that evidence included the physical setup of the hog. There was no other way basically to clear it out other than to get in through a door at the very bottom of the hog. The company provided very rudimentary tools to do so, basically a stick with a mirror on the end. There was no training for employees in how to clean out the hog. There were no prohibitions on entering the hog. The company, as Mr. Hunt said earlier, had been asked by workers and frontline supervisors to redesign the hog, and it refused. And clogs of the hog were very common. So from the steelworkers' standpoint, I would say from a reasonable person's standpoint, the evidence was clearly there that the company ought to have known about these deficiencies and should have taken reasonable steps. So I just offer that by way of, obviously the issues about resources are very important to understanding why it is that Crowns don't proceed. But sometimes it is possible to look at the legal reasoning and the evidence in more detail and come to a different conclusion.
Just one moment. Is that document privileged? Is that document open to the public?
Yes, it's
Yes,
a press release.
Okay, it'd be great to have that put on the website, the Westward website, and that way everyone here can have access and can judge for themselves. I think that's great.
I can't help but comment. I think that when there's an indication that there's evidence from the Workers' Compensation Board, it may not have been evidence that the Crown felt was admissible with respect to a criminal prosecution. It may have been compelled by provincial authorities. I don't know that for sure. It just strikes me as an issue on the face of it. And as alluded to earlier, the dominant purpose test in Jarvis and Ling will, from the Supreme Court of Canada, will tell us whether or not the evidence is admissible in any further prosecution. That would include a prosecution under the criminal code. So I don't know enough about the facts, and obviously it wasn't me making the decision. I guess the only other question I had was whether or not that matter was prosecuted under provincial statute.
I believe, yeah, it was. They ended up getting fined under the provincial regulations in the end. Yeah, but the actual criminal prosecution was stayed.
And I think the other issue that's kind of evident on its face is if you have a Crown exercising discretion and you purport to substitute your own discretion for theirs by way of initiation of a private prosecution, I think the only thing that you can expect is pushback.
Great. Any other questions? No questions? Great. All right, well, thank you very much to my panelists here.
I think Mr. Jones.
So I'd like everyone to stay in their seats just as we do a quick change and bring up our police panel. So people on the police panel, please come to the front. And so, without further ado, I give you Pat Van Horn.
I think it's on now. Good afternoon, everyone. My name is Pat Van Horn, and I'm the United Steelworkers Legislative Representative here in Ottawa. I worked for the Steelworkers Union for 23 years, and in one way or another, have been part of the Westray saga since that Saturday morning on May 9th, 1992, when the deliberate actions of mine owners and managers resulted in the deaths of 26 fathers, brothers, lovers, and friends. Everything changed in Pictou County that day, and 11 years after that, Canadian parliamentarians showed unusual solidarity by unanimously voting in favor of the Westray Bill to bring corporate accountability into the Criminal Code of Canada. And that's something, by the way, that will never happen today in the Parliament that we now have. And it's ironic that the next omnibus budget bill that's before the House right now is called Bill C-45. No more Westrays was our rallying cry, and the Westray changes were a great victory for the labor movement. But as we've heard here today, everyone now understands that justice for the families of thousands of workers who have been killed at work remains elusive. This panel, the last panel of the day, will look at enforcement issues from a policing point of view. I will introduce the panel members to you, and I will prompt the discussion amongst the panelists with a single question, which each panelist will answer from their own perspective. The conversation will continue, and then we will open it up to the rest of you. So, okay, our members of our policing panel are, at the far end is Kevin Sador. You heard his name brought up earlier today, and he's with the Toronto Police Service. In the middle, we have Mr. Michael Van Katz, who is a director of the Investigation Services Branch at the Province of Manitoba, Family Services and Labor Programs. That's what it says in the thing. It's an awful long title.
Sounds more important than it is.
And on my left is Monsieur Robert Bronsard from the Association de policières et policiers provinciaux du Québec. So I'm going to begin because jumping off just from the last panel, I'm going to start with Kevin, and I want to know first of all how you got involved in the Metron case and what you learned from it.
I'm a divisional investigator with the Toronto Police Service, so my duties are far and beyond just work-related deaths when I still carry a full caseload of other investigations that span the entire criminal code. December 24th, 2009, I was working an afternoon shift. Christmas Eve, everybody's gearing up for Christmas and whatnot. I let my guys go home, and within an hour, the tragic incident took place. With it happening within my division, I'm automatically the first one on scene, and I take the investigation from that point. Didn't know what I was getting into at the time, but the more that I uncovered, the more that I seen that something had to be done. There was just a litany of people like to use the term of non-due diligence. And that's exactly what I seen here, just with knowing nothing about the construction industry. Just things did not make sense to me from a common sense perspective. And I knew in my heart and my gut that there was more here, and there was people that had to answer some questions. And the investigation just carried on from there. I then educated myself with regards to Bill C-45. I was in the process of dissecting it when I got a phone call from the Ontario Federation of Labour from Mr. Vern Edwards, who was on the panel proceeding here. And him and I had a discussion over the phone, at which point I told him what I was doing, and he said, oh, basically I have a Bill C-45 for dummies, which was perfect for me. So he passed it on electronically, and it cut down a lot of time and let me get down to the actual investigation as opposed to trying to, like I said, to dissect Bill C-45 and 217.1 of the Criminal Code. I mean, that's pretty much self-explanatory. But then getting into the non-due diligence of the people and the responsibility of those persons directing work, it was pretty cut and dry to me, and there was no question in my mind which way I was going to proceed. The investigation carried on for almost a year. I laid charges in October of 2010, and we are in the midst of a 3-month preliminary hearing right now. It continues again in January. You've also heard prior that there's 3 persons that were there's 3 persons that were arrested. They separated the information. The day that the preliminary hearing was supposed to start, there was resolutions that were in the works that were, again, above my pay grade. The owner and the corporation pled guilty. You've also heard here that a fine was levied. Total amount was $343,000. That's including the criminal as well as the Occupational Health and Safety Act infractions, and the victim surcharge, which is applied here in Ontario with regards to certain offenses. So basically, breaking it down, if anybody's interested in what a human life costs here in Ontario, it's about $80,000. If you break it down to the 4 persons that were killed and the one individual that received horrendous injuries and is still working its way through those right now. So that's basically how I got involved with Bill C-45, and then Vern was nice enough to, like he said, he would investigate any other injuries or workplace deaths throughout Canada, and would give them my name, and I was getting phone calls at all hours of the night. So that was interesting. But by all means, you know what I mean. If sitting there with the wives and the mothers and the fathers and the children of the victims of this incident, I mean, you got to do what's right. You know what I mean, in your heart, and you're going to do what's right. And that's what it was with me and the officers who I spoke with from across Canada who are going through the same things that I was. It wasn't a question of doing what's right, it's a question of how. So there's a lot of, I'm sure we'll get into this a little later, but that was it.
Okay.
Corey has, and his colleagues have put together this workplace death and injury manual for police, and I've disseminated that all over the place so that it'll cut down on some of the phone calls that I get. And it's plain doctrine, and sets out everything you need to know to conduct an investigation and how to start.
Thank you. I'm going to come back to Kevin a little later on the issue of motivation, but I want to ask Robert if there is anything unique in Quebec that makes that environment any different, and how are you going conducting investigations in that province?
First of all, I'm not a member of the SQ Provincial Police.
To listen to me, then it is in French. So,
I'm not a member of the SQ, so I won't speak of their methods of investigation. I am a member, professional employee of the union for representing the SQ officers, and I take care of safety. The investigations made by the officers when an accident happens, work-related, we heard it several times today, and it's the same story in Quebec. The officers don't have any particular training to make the analysis in the workplace. So they intervene with the means that they know to make the investigations, usual criminal, as Kevin said earlier. When he arrived at the premises of the 4 men, of the 4 workers, he spontaneously said, I knew something was amiss in the way the organization had been done. So the point that he raises is that it was obvious. The problem that we have in work-related accidents the cases are not always so obvious. If we take the file of in Ontario of the worker who went in a hole to build, he did not build a proper cage around him. The worker died because there was the earth caved in on him. The chief, the boss said not to make the casing. So the link of causality between and the representative of the employer. So it was obvious there, that link. But if you have a situation where a piece of metal comes loose and that it's tied to a chain, somehow it falls, and it falls on a worker. So the investigation, the investigator, he looks at the situation. There's no one there that dropped it or that cut the chain, so the link of causality is not direct. There will be the coroner's investigation and also of the CSSD. There is no link between this loss of life and a physical person to which it could be related to. Since we discussed this morning, we spoke of training. So the analysis of accidents in the workplace, this is a field, a specific field, where one studies the process and not simply a link between cause and effect, but we study processes. What to follow this to methodology in such cases. According to these methods, one will investigate on what brought about this thing to happen. When I do training with prevention representatives, when you make an analysis of an accident in the workplace, I'm talking about 3 years. Why? Always the why. And then why was this there? But why was this piece left there? And just go back and go up to the point where you will find the whole chain of causality. So the training of investigator is not of such nature. We look at the link, the direct link, because the officer his training is to find someone guilty, a culprit. So where the difficulty shows up in the fields of investigation of the coroner and the CSSD and the police, it's when the coroner and the CSSD, they do research to be able to make recommendations so that this won't happen again. So their perspective is the future, not is there a criminal liability here, responsibility. They're not looking towards the past. They're looking towards the future because they want to make recommendations. So we have nothing against that. But these reports, to answer your question, in whole, there's no one that really makes an analysis of the criminal nature of the event, unless it's so obvious.
Okay, that brings me to Michael. I want to know if you can answer this question, because a couple of things that were said earlier today was that regulatory agencies have the ability to compel evidence, whereas the police cannot do that in these situations, apparently. And and another thing that Steve referred to today was that when the police do step in, everything's already gone. There's no, the crime scene hasn't been isolated, as it were, as it would be if it was a shooting or another act like that. So I wonder, can you tell me how could police and regulators work better together?
Thank you. That's actually an excellent question and is really relevant on what I'm currently doing out in Manitoba today. I come here today actually wearing two hats. The whole concept and notion of workplace health and safety is something that I'm relatively new to. I'm a recent hire with the province of Manitoba, with my current position as the Director of Investigations for the Workplace Safety and Health Branch. What I do now is I oversee a team of investigators
safety and health officers that look into serious incidents that have occurred in the workplace, serious injuries and/or fatalities. And what my team do is they will go and investigate the incident and look into why it occurred, what were the causes, both directly and indirectly involved, and then we take a look at the investigation in its totality at the end and determine how are we going to then proceed with this. And there's various options available to us. If it's something that can be dealt with at the employer level through improvement orders and through working with them to get them to where they need to be, that's one. If it's something that we see might be systematic in that particular sector, we're going to want to educate the sector to ensure that incidents of that nature don't occur again in the future. We try to, mitigate that. And of course, if there are offenses that we have identified against the Provincial Act or criminally, which we already know in Manitoba, we haven't crossed that line yet. The investigation is forwarded to Manitoba Justice for consideration for charges. So that's my current job. Now, again, I've only been there less than a year. Prior to that, I was a member of the RCMP for 23 years. And all my service was in Manitoba, and my service ranged from being a boots-on-the-ground investigator to getting into criminal intelligence, where I was developing sources at street level, working in integrated organized crime investigations with my counterparts with Winnipeg City Police. Eventually got into witness protection. I was involved in the National Witness Protection Program. And when I left the RCMP in my 23rd year, I was a detachment commander of a detachment just on the outskirts of the city of Winnipeg. Prior to my hiring to the province, there were discussions between Workplace Safety and Health and Manitoba Justice about how can we improve the quality of the investigations that are being conducted by the Workplace Safety and Health investigators. And fortunately for me, one of the decisions that they decided was something worth pursuing is perhaps we should get somebody that has an investigative background that they can bring to the table, and based on their experiences, in my case with my service with the RCMP, we can perhaps make modifications to the way that we're doing our investigations and potentially provide a better product. One of the initiatives that I've begun since my arrival with the province, I think it's really crucial that the lines of communication between provincial investigators and law enforcement, whether it's the RCMP or in Manitoba, Winnipeg Police Service, and to a lesser extent, there's some other municipal services, those lines of communications have to be open. Traditionally, when you have a workplace incident that occurs in Manitoba, the only time the police are notified is if it's a fatality or if it's an injury that's serious enough in nature that it could potentially become a fatality. Then the police are advised. The police are the first ones to respond to the scene. Workplace Safety and Health investigators are also made aware, and they will go as well. But initially, the scene is the responsibility of law enforcement. And they'll look to see if there's any elements of criminality. That being said, the kind of things that they're going to be looking for are going to have to pretty much be blatantly obvious to them when they're at the scene. Okay, so let's take an example. A worker's fallen 30, 40 feet off scaffolding and is deceased as a result of that. An officer is going to arrive at the scene, and the things they're going to think about, okay, criminality, what can possibly have happened here that might have been criminal? Okay, well, was he pushed? Was there an assault that took place? No. Were they under the influence of alcohol or drugs? And so they're going to look at, again, kind of the obvious things. If nothing jumps out to them initially when they're at that scene, they essentially then become an extension or an agent of the Chief Medical Examiner's Office. Now they're going to be investigating this incident under the Fatalities Inquiry Act. They're going to gather all the evidence at the scene, seize exhibits if necessary, or if there's a need to. They're going to speak to witnesses. They're going to speak to the Chief Medical Examiner's Office and it's going to sound cold, but get the authority to remove the body once we can do that. And they'll conduct their investigation in that manner, put together a complete package, and that package is then forwarded to the Chief Medical Examiner's Office. And the Chief Medical Examiner will then take a look at that and determine whether there's any needs to be looking at it any further through inquest or inquiry or that sort of thing. When the police officers are finished dealing with the scene that they are at, they don't release the scene. They turn it over to the workplace safety and health officer. So the scene is still secured. That's when workplace safety and health take over, and then that's when our investigators do their due diligence and commence their investigation. So again, if there's they'll do photographs, they'll do measurements, they'll also determine who the witnesses were involved, they'll identify the players as such, they'll take a look at what equipment or what machinery or what was involved, and once they are satisfied that they no longer have to secure the scene, once they've gathered as much evidence as they see that they can from that scene, it's then that it's released. And then they continue with their investigation. So going back to your initial question, how can we ensure, I guess, that the left hand knows what the right hand's doing and vice versa? It goes back to, and I'm going to sound like a broken record here, but the lines of communication have to be open. They have to be well established. And what I've been doing since my arrival, and I'm very fortunate that Manitoba is a fairly small province, so I spent 23 years in Manitoba. With a name like Van Katz, it's a name that's easily recognizable. So when I speak to my counterparts with the RCMP, in most cases it's people that I've worked with over the past 23 years, or at least they know who I am. So we have a real good working relationship with the RCMP in the province. Recently I took a look at their policies and procedures and how it relates to how the RCMP respond to workplace safety and health issues. Took a look at them, and through working with the folks in their Criminal Operations Policy Center, we were able to tweak a few things here and there to make it a better document, and to remind the officers that they should keep criminality in mind when they're attending these incidents, and don't just automatically go towards the mindset of investigating under the Fatality Inquiries Act. Currently in the process of doing the same thing with my counterparts, or my former counterparts, with Winnipeg Police Service. And again, because of my past experience working on joint organized crime criminal investigations with these folks, again, we know each other, a lot of the officers that I've been dealing with, so I'm going through the same process that I went with the RCMP, and I'm currently looking at their policies and procedures. What I'm also going to do is, at Workplace Safety and Health, our own internal policies and procedures are due for an updating. And they were actually prior to my hiring. So once we have a chance to take a look at the RCMP, Winnipeg City Police, I'm then going to tweak ours as well so that we're all on the same page. And we'll just assure among all the organizations that we have that ability to maintain proper and open communication with each other.
Thanks a lot, Michael. Just to compare and contrast, do either Kevin or Robert have any comments on how it works in your particular jurisdictions?
From what my colleague said, what I really understand is that it's the Department of Labor that hired you?
Workplace Safety and Health, Ministry of Labor.
Yeah. Alors, quand c'est le ministère?
When it's a Department of Labor, that sends a very clear message to corporations. We don't have that in Quebec. We don't have this unit from the Ministry of Labor that is mandated to do inquiries and to establish coordination between the different services and departments that can be involved. And now there's a structural problem. In Manitoba, they have a structural and organizational solution for a problem that came up a number of times today. In other words, how can we ensure that there is follow-up after an inquiry, because the responsibilities are fragmented among the police, the Crown, the WCB, and the prosecutors who will receive a file or not, but he hasn't had any special training
in analyzing work-related accidents, he doesn't really know what he should ask the investigator to do to improve the information in his file. So if Manitoba has set up these measures, I think that they wanted to send a clear political message to the corporations and the companies. So they're starting to work on that, and that seems extremely interesting to me.
My colleague Mike has said with regards to working with other regulatory bodies. In Ontario, there's several different bodies we work with, but I'll use the Ministry of Labour as an example. There's several problems when police arrive on scene to a serious workplace accident, industrial accident, construction accident. With the Ministry of Labour, we're usually the first ones on scene. The Ministry of Labour, for example, is brought in secondhand. We secure the scene, and we usually defer to them as being the experts, whether it be for whatever it could be any construction site, it could be any type of machinery. We'll secure the scene. We'll allow them to conduct their investigation. We'll identify who the witnesses are. We'll attempt to notify next of kin depending on the seriousness of the injury. But for the most part, we let the Ministry of Labour do their thing. And as somebody alluded to earlier, once they're done, we usually kind of we'll hold the scene for them until they're finished their investigation. Our forensics officers will a lot of times assist them with photographs or transporting of evidence. But for the most part, they do their thing. We assist facilitating them. What I've been trying to speak with my fellow officers and investigators is just don't stand there with your hands in your pocket. Take an active role. Sometimes that may mean speaking to the Ministry of Labor investigator and saying, you know what? But again, we have to be careful. What did you hear? What did you see? What was told to you? And as my colleague from the RCMP said, police go in there and say, you start talking to somebody, hi, I'm Detective Sador. What happened? Crickets. Nobody wants to talk to you. Nobody wants to tell you anything. Whereas if the Ministry of Labour comes in, they're compellable witnesses. They have to speak to the Ministry of Labour investigator. With that being said, whatever is told to that Ministry of Labour investigator cannot be told to us. So we have to conduct almost it's a parallel yet separate investigation without crossing the lines. Same with if Ministry of Labour investigator goes in, he seizes a certain piece of equipment, and then 3 hours down the road, we think there may be some criminality. It's our crime scene now. That's our evidence. They cannot just give it to us because they seize it under a provincial statute. We can't use that unless there's a warrant that is written for it. So it's difficult doing the parallel separate investigations. A lot of times it's like, you know what, officer, detective, I think you should speak to John Smith. He may have something to tell you, as opposed to saying, John Smith told me, blah, 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 blah. So there's a very, very fine line that we have to walk when conducting the investigation with Ministry of Labour or whatever other regulatory body. I can tell you that sometimes, and I've seen it before, where the Ministry of Labour investigator and the police will get into a boot fight because they'll say, okay, well, this is my scene. No, this is my scene. No, this is my scene. So they don't like to hear it, but criminal code takes precedence over provincial statutes. So, that's not a good way, a good foot to get off with when you're working with somebody who you're trying to work together to achieve a common goal.
Sounds like there's a lot of work to do on this one. I think we just have a couple of minutes before we open it up to questions from the floor, but I just want to ask you all to respond to this question, and that is with respect to the discussion this morning about the culture of, how we view workplace negligence as different than the kind of criminal negligence that happens, like Steve Hunt used the example of drunk driving, etc. How can we motivate police officers to investigate workplace fatalities and serious incidents as potential criminal events. There, not everyone is going to be a West Ray, we know that, but how can we make people want to investigate these things as though they may be? Any ideas? Who wants to go first?
I'll go first. I think
Okay.
with me, it starts off with the education of the investigators. When we're going through the police college, depending on where it be, it doesn't matter what service you're with, this type of investigation is not taught. It comes through experience and education, as we're going through right now. I believe it was Professor Johnstone had said that events, police were kind of programmed to investigate events that are committed by individuals with a mens rea. That's the police mindset. We're looking for particular individuals who committed an act and had the intent to commit that act. To me, that's where it stems from, is you have to get them to start digging a little bit more. I tell officers who I deal with, I said, treat it like a suspicious death. You get a suspicious death, you walk into a home, you find somebody in the basement covered by, in a pool of blood. You're not just going to go, oh, well, they're dead, and it looks like a heart attack maybe. Well, we'll let the doctors figure it out and walk away. That's the kind of mindset that I tell my investigators who I'm speaking with and who I deal with, as well as those on my team. I said, you know what, do a little bit of digging, and you'd be surprised at what you may find. But don't go in with the mindset that every single accident or fatality is a homicide as well. That's the mindset that I try and get them to go with.
Michael.
And maybe I'm naive here, but I don't feel personally that there's a real a need to motivate law enforcement officers to investigate workplace incidents for criminality. I agree with my colleague Kevin that there's probably a lack of training as far as preparation to deal with these particular incidents. Again, from personal experience, I can tell you that once officers attend the scene of a serious incident or fatality, and in their mind they don't see anything again that jumps out at them, that there's some criminality involved, they rely heavily on the workplace safety and health investigators. We're considered, I say we now, we're considered the subject matter experts. We know the act inside and out, the regs. And again, going back to, I'm sounding like a broken record, this is where the lines of communications are very, very important. If our investigators come across some bells and whistles or some troubling information, potential evidence to suggest that maybe some criminality is involved, that's when we go back to the law enforcement agencies. And of course, this would be new ground for us because we haven't been there yet with Manitoba, but Manitoba Justice would be intimately involved in that as well. So at the first indication that we have that there might be something a little more sinister at play here, that's when we would involve the agencies. And quite honestly, so far I don't foresee any difficulties with law enforcement taking the ball if we can show them that there's something there.
Hey, Robert.
In the same order of ideas, I don't think that the police need to be motivated to do an inquiry of this nature. It's part of their job, but I said that training for analyzing work-related accidents, it's a very special kind of analysis, and they have to be refined. There's also the fact that the culture of risk with police officers is there. It's very difficult to do prevention and say, be careful with risks. Their work itself is to take risks. It's part of their culture. So the approach to risk is very different with a police officer. Very often in their work, they're confronted with accidents on the highway, inside a home. And people who die during accidents. We said that sometimes these accidents are trivialized. That's part of the police culture, perhaps, because they see them so many times, they can really trivialize things. They can say it's just an act of God. I don't think that we should really think so much about training each one of the investigators in Quebec. There are many investigators throughout it's like the Ontario Provincial Police. That's too many people to train. Many of these people won't really intervene very often, so they won't have the opportunity to develop that kind of skill. But instead, and that's where I like the idea that they're using in Manitoba, to deal with this lack of training with the organization of links between the different skilled people in the WSCP or the coroner's office or what, so that there's different inquiries all end up at the same place. The police, the coroners, the WCB could all end up with a Crown prosecutor who could have a special training and a special awareness of criminal liability of corporations. For work accidents, you have to prosecute a legal entity, whereas police work is always deals with a person who caused an injury to someone else. Now, if we talk about a legal entity, we have to talk about the work process and come back to this notion of the voluntary blindness that actually caused this accident. It's not an issue of motivation, I think. I think maybe a problem with training, but I'm not really sure. In the training of police officers, but we have to coordinate the different skilled people who will be intervening in any case when there is a work-related accident. It all has to come together at one point. That's what we have to organize.
Thank you all very much. That's this part of the panel, but now we can open it up for any questions or comments from the floor. Okay.
I have a comment and a question. I do some part-time prosecuting for conservation authorities in the province of Ontario. When we have a case where we have to prove that there's been a violation in a floodplain, one of the things that we do is we hire an expert witness. And the expert witness testifies, qualified by the court as an expert witness, that indeed this is a floodplain. It's a technical issue. That's my comment. The question is, when you're investigating a case like this, and we're dealing with market departure from the reasonable standards that would have prevented this accident, have you given some thought to hiring an expert who would be qualified as an industry expert? Because I can assure you that the defense is doing it, to testify that there's been a market departure from the industry standards. And I appreciate that this costs money, but it's something that I throw out and ask you, have you given some thought to doing that?
I'm not sure if that's a police issue, but anybody that wants to take it?
I can tell you that that we do that, and it has been done, and it's being done as we currently speak. I can't go into particulars with regards to that, but I can tell you that just by a lot of times the evidence that we seize in these type of incidents goes far and beyond the scope of testing that's available by the Center of Forensic Sciences or by our forensic identification officers. So it's outsourced, for lack of a better word. And again, it comes down to money. Most of the cases that I've dealt with, the Ministry of Labor, the province has actually picked up the tab, and they'll hire an outside source, and it could be even outsourced by that source, which, especially when you're talking about the rules of evidence, the continuity of those type of things, is it causes a lot of problems, a lot of concerns from a policing perspective, because you're taking something that, this is your evidence, and it's the most important piece of thing out of a 2-ton piece of machinery. and you're handing it off to somebody, and then they're handing it off to somebody else, and you don't know where it's going, you don't know how it's being tested. A lot of time the testing is destructive. So the short answer is yes, we do hire experts, and they're usually very, very competent.
Thank you.
Okay, Michael, do you have any comments on that one?
I can say that from the Manitoba perspective or point of view, I'm not aware that we've looked at that avenue. Oh, but I have my Crown Attorney here, which apparently would be before my time, saying yes, that has been done. So,
Robert?
there you go.
Well, not being a member of the SQ, I don't know of any investigations. I can't answer for this. Us as a union, we will go and seek people as a representative of the police. We will seek people as experts.
Hi, I'm Kevin Rebeck with the Manitoba Federation of Labor, and I'm glad to be here with a good cast from Manitoba. We've got David from the RCMP, who's come along and has been meeting with us, and Michael, and you've heard from Sean as well. And we've been working at this, and I want to share a little bit of information, and then I've got a question for the panel as well. And really, Labor got involved in this because it's critically important for our members, and we have members who are killed every year. And we worked hard, we lobby, we push government, and we push to change rules. That's what we do. We were successful. We got a law changed. And you'd think that that would have made the difference. But the reality is, getting that law into practice, we're facing a lot of challenges. So we've been working at provincial levels now to figure out how to do that. And I give credit to the OFL. We saw their package and what they were doing in their province, and we thought we need to get this conversation going in Manitoba. About 2 years ago, we started that conversation, and we've had very good talks with the RCMP, who are very receptive, with the Attorney General and his staff, with the Minister of Labour, with the Department of Health and Safety, Winnipeg Police Services. We got a number of dialogues going, and all of them were very open and receptive to looking at this issue and seeing what could be done about them. All of them also identified that there are gaps. There are pieces missing in our policies, there are pieces missing in our procedures that we need to fix, and we need to close and repair or make work in a better way. So we've been looking at figuring out how to best do that. But even as I listen to panelists discuss, and we jokingly say, that's above my pay grade, or we make reference to, we get crickets and we're hitting barriers here, or we make reference to the collection of evidence. And this was an example that came up early and has been repeated in all the conversations we've had with groups. We say, that the police can't collect evidence the same way. Well, we're willing to fight to change whatever rules need to change to make it happen, but we need help in understanding what else we need to change. We thought as labor activists changing the law would make the difference and make this work. And we recognize that all of us players at this table who want to make the law work, but there are some barriers there, and we're hitting them. That's one of them that I've heard repeatedly, the collection of evidence. So we're prepared to figure out, how do we change that? Does another law change required? Is a regulation change? Is it a policy? So I guess my question for the panelists are, if you had the authority, if you had the right pay grade, you had the authority and the resources, what advice or guidance for change, whether it's in law enforcement or if it's with one of the partners here that help make this happen, would you like to see happen so that we can help fight to make that change?
Yeah, I'll start from this end first, Robert.
I started answering your question a little earlier when I stated that we have to organize one point of delivery so that the whole of the information that was found in the different analysis be taken in charge by one single entity or one single person. It's the fragmentation of the information, of the evidence, that's a problem, more than anything else, because it manifests a fragmentation of responsibilities, which is not conducive to success. So I believe it should land in the hands of a Crown Attorney so that this Crown Attorney can assemble, have all the data necessary, and from there, if this Crown Attorney deems it necessary, he should ask or could ask to the police force a complement of investigation. for the dimension, for the strictly criminal dimension. Otherwise, I find that the idea of Manitoba there's something to explore, and I will toss the question to Michael, obviously.
I'm going to deal specifically with evidence because that seems to be the topic that's reoccurring. I don't think we need to change anything as far as laws or policies when it comes to evidence. If a workplace safety and health investigator has seized evidence through the powers that the Act provides to them, whether it's documents, training records, memorandums, any sort of evidence that would be supportive in possibly proceeding criminally, it's not an issue getting those to law enforcement agencies then so that they can use that evidence in their investigations. It might be something as simple as a search warrant, which is fine. Law enforcement agencies are writing up search warrants on a daily basis. It's not an insurmountable challenge. Again, with us here in Manitoba, because this would be groundbreaking in the sense we haven't had that experience before, we'd liaise again with Manitoba Justice to make sure that we facilitate the transfer of that evidence to law enforcement so that they can then use it in their investigation and we don't have to worry about the topic of inadmissibility down the road if it comes to prosecution.
Do you have any comments, Kevin?
There's not a problem with the rules of evidence with regards to our search and seizure procedures, and I agree with Mike that anything that is seized by any other regulatory body we can obtain by getting a search warrant. Sometimes it's not the most cost-effective or time-effective means, but you know it's better to do it now than to lose it in court at a later date. The biggest factor that I've had a problem with is the compellability of statements from witnesses and other persons. Once they realize that the level of jeopardy that they're facing is greater than what it is from a provincial statute, they clam up. That's the problem. If I could change anything, it would be whatever statements that are obtained by whatever other regulatory body could be obtained and used by whatever police agency is conducting the investigation, because that's where most of your evidence, most of your best information is going to come from actual people who are employees at a particular scene.
Thank you. Okay, question over here.
Oui, pour répondre au commentaire.
Answer to the comment of Mr. here. To find out if experts or expert witnesses can help during investigations and during prosecution, to have worked as a witness expert, to have been in contact in the Commission of Inquiry, Belmoral, and for unions, professional orders, and businesses, private enterprises. I've done all sides. I've been on all sides. So you can't color me with one brush or the other. I've been everywhere. So I'm quite, I can be neutral in this matter. What I can say is that the expert brings a minute knowledge of the equipment, of the tools, of what is used. And in many cases, this has contributed an understanding of the testimonies already gathered. I remember this witness is not trustworthy. I'm not going to court with this guy. I'm going to get clobbered. This will not work. This guy won't stand. I read the testimony and I told them what the witness just said is such and such a piece of equipment. Look, this is what it is. It's such and such for a layman who begins in this. It's normal to describe the object in such a rudimentary form. If he describes it this way, it's a narration, correct, exact, of the events as they took place, of the equipments that were used. And suddenly, after 2 or 3 testimonies that were revisited, his witness became a solid witness, and he was ready to take this all the way. So on the contrary, I've seen cases where there was no prosecution because the lawyer realized at one point that the report, the technical report, was in contradiction, something obvious, and that anybody expert of the defense could demolish it in no time from the get-go. And I believe that the people who are experts in the field, and after several years, I'm not expert in all the fields of health and safety in the workplace, we can bring you this look, this way of seeing things that for you may seem sketchy or not important, or for us are important indices. So I believe that this collaboration will make you get some headway in this by ways of communication between the police and the investigators in health and safety in the workplace. To shed this light will make many cases go ahead.
That witnesses that you have need to come from both sides, the person that's telling the story of what happened and the technical expert witness that knows the situation in a deeper way.
Yeah, the expert, in fact, is able to interpret all the facts in a scientific way, to put, we'll say, a logic in things that sometimes the fact witness, the workers, explain in their own words. We are able to put some kind of equation in that, some science, some logic. And then at the end, we have a real logical portrait of the thing that could be explained in front of the court, and the judge will understand what is going on. It's that what we are able to put all the piece of the puzzle all together and make a full knowledge of that. The lawyer is not able to do that. He's in logic. He has a great logic in law. He's understanding very rapidly a lot of things, but he do not have the basic knowledge of that. When we instruct him, I will say I have a very good friend with lawyers, attorneys, no problem. They are fast to catch it, but they need to be fed.
Right.
That's the role of the expert.
Anybody got any comments up here?
I would just add that expert witnesses are also a double-edged sword. They can come up and bite you as well. I've seen that before.
Okay, this microphone over here.
Once again, Greg Yost from the Department of Justice. Several people here are aware that this C-45 was the first major file I got when I went into criminal law policy. So I did appear in front of Parliament when they discussed the bill, not the bill part, well, when they discussed the bill, yes, but also when they were holding their hearings. There are certain things that I think people have to understand the framework of the criminal law. You know, the question, you know, what would we have to change? What pay grade would you have to be at? Well, you'd have to be a Supreme Court judge to change certain things. The right to remain silent, the right against self-incrimination. The moment the police detain you, they're supposed to give you your right to counsel. If they don't do that, that won't appear. You know, you can't use that. The Supreme Court, in cases dealing primarily with driving, has definitely established, wait a second here, there's criminal liability is the worst thing that you can impose upon someone. That's the worst hammer we've got, and it's not to be used lightly. You have to have something that really says that this should be denounced at the highest level by the courts and Canadian society. They've held that there's no place for strict liability where someone can go to prison or anything like that. So, you know, if we're going to be dealing with criminal law, which is what C-45 is, you have to work within these parameters. And in terms of compellability, again with my other file dealing with driving, it's a recent case of the Ontario Court of Appeal. Dangerous driving causing death. The only way the police could place the guy behind the wheel. Lots of people had seen the bad driving, but nobody could put him behind the wheel. The only way they could get him behind the wheel was he reported the accident under the Highway Traffic Act. He's supposed to report it. That was a compelled statement. They couldn't use it. Acquitted. That's, you know, the way the criminal law works. And until you're accused of a crime, you might think that's not a good thing. But, you know, You got to look at it from both sides. The person who's facing the worst thing you can have, being found guilty of a criminal offense. You won't be able to travel to certain countries and all that kind of stuff. So there's always going to be an extremely high threshold for obtaining a conviction under the criminal code. It's not something special with labor accidents or anything. It applies across the board. That's all I wanted to say. If anybody wants to comment on it, away you go.
Just to go back to a comment that Kevin had mentioned earlier about in a perfect world, what are some things that we could change to help facilitate criminal investigations? And one of them was that provincially, under the provincial statutes, employers and employees and witnesses are all compelled to provide statements to provincial regulators or investigators. And I mean, if we're looking at being able to take those statements that are being obtained and then hand them over to law enforcement for possible criminal prosecutions, basically what we're saying is we want to suspend these folks' rights under the Charter of Rights and Freedoms because they were compelled to give a statement under the Provincial Act under the knowledge that it will be used with the enforcement of that act. Now, if we're going to go and possibly proceed criminally against them, these folks are protected under the Charter of Rights and Freedoms, and one of their first rights is I have the right to remain silent and to speak to counsel, and I don't have to speak to you. So that's the challenge that we would be facing. But like I say, in a perfect world, that'd be sweet. Yeah. Yeah.
Steve.
Thank you. Yeah, I mean, I have a comment, and it's not at all directed at you folks, actually, and it's not any more or less relevant to issues about policing and investigation, but it is the kind of comment that I tend to make at some point in these events, and it is the kind of comment where people look at me and kind of agree, but they think I've been a pain in the arse and roll their eyes as well. I understand that, but look, I'm going to make it anyway, because it's about something we can change. It's about something we can change easily, and it bears upon issues of cultural representations of real crime, what happens in the workplace, and so on and so forth. So it's this, look, and if we can't do this, we can't expect folk out there to do it, right? Can we all consider, I can't tell you what to do, right? I'm too small for that, for most of you, right? But can we all consider the ways in which we use the term accident, please? Workers get killed, workers get injured, workers get maimed, in Harry's language earlier on, workers become sick at work, and so do other people who are not direct employees as well, of course. Now, we may be talking about accidents, or we may be talking about offences, but to immediately refer to an injury or an incident as an accident, of course, immediately conjures up a whole series of connotations, assumptions about intentionality, foreseeability, preventability, which automatically start to separate out that event, that death, that injury from real crime. And I wouldn't want to sit in a room with any of the families of those who were killed at Westray and start talking about the accident that killed their father or their brother. So look, like I say, it's a bit preachy, right? I can't tell anyone what to say, but I think we should be a bit more careful about our use of language. There are accidents and there are crimes, but we can't prejudge them.
Thanks, Steve. Anybody want to comment on accidents? Nope.
I agree with you.
Okay, we all agree. Yep. Great. Catherine.
Yeah, I was wondering whether I was going to say this, but you've really opened the door for me. My husband worked for the Workplace Safety and Insurance Board here in Ontario, and he told me so many times, or looking around the house, that one of their slogans at work was always, "There are no accidents." And, that's a bit of an exaggeration, but the slogan was, "There are no accidents," because when you go to work in the morning, there's no reason for you not to expect to go to work, do your work, and come home. If you're dead at the end of the day, or you're missing limbs, or you're a bloody mess, that's not an accident. Something happened there that shouldn't have happened there. And that's sort of the starting point, right? This shouldn't happen. No one goes to work expecting not to come home. And so something more than an accident happened there. That's where you start. And it would be rare and unusual if you in the end said, geez, this really was just a freaky accident, So that's kind of, just wanted to throw that out there.
Thanks a lot, Catherine. Seeing nobody else at the mic. Oh, wait, Nina at the mic.
Thank you. Yeah, I just actually have a comment that kind of I'm going to take sort of off of Steve's, I think, and that is that, in BC, and it kind of goes to some of the things that you were talking about already on the panel, and that is either waiting sort of for the WCB to do their investigation and to try and determine whether or not there might be some criminal activity and then get the RCMP involved, or what we see happen more often than not is unfortunately the RCMP show up at the scene of the scene of the incident and decide within, I don't know, a short period of time anyway, in the same day, that there's no criminal activity. And I think there's some huge problems with that. And first of all, with respect to the RCMP showing up or police and showing up and making that statement, especially publicly, I think it sets the stage for the WCB investigators. They already have it in their mind that, oh, there's no criminal accountability here, and that's how they proceed with their investigation, which I think is problematic. But also with respect to waiting for the board to be done with their investigation or come to a point in their investigation where they think there's maybe a problem. Again, I have to agree with the document that the CLC has come up with that I mean, most of the WCB investigators aren't trained to look for criminal stuff. First of all, they're looking for regulatory offenses. Second of all, the time it takes for them to do their investigation is extremely lengthy. In most of the serious cases that we've had, they literally are finishing up their investigation at the 2-year mark, just before they can send it to Crown. And so, again, it's too late. I mean, the evidence has gone cold, so to speak. You know, in some of the cases that we've looked at, and where the police unfortunately were not involved from the beginning, some of the witness statements were taken almost a year after the incident occurred. And again, I mean, I watch Law and Order enough to know that that's not good enough, right? And of course, the witness statements are going to be well, potentially either persuaded by the employer if they're still working in the workplace, or just, you know, shifted over time based on their memories. So anyway, I think it's really important the work that the Ontario Federation of Labour, et cetera, is doing with the Ontario Police Services. So I'm just sort of wondering, what's the best approach for BC? Because we're just sort of starting this conversation in BC, and we want to know how to approach them and start to build the kind of relationship that you've been able to build with Vern without stepping on their toes. I mean, we don't want to offend them and say, hey, by the way, you need training. But we do want to start that conversation, and I'm just looking for some sort of tips and tricks, I guess, as far as how to move forward with that.
Kevin, I guess that's up to you.
You could always take them out for a beer or something like that. That's a good place to start with most law enforcement officers.
And then go out driving?
Yeah. I really don't know how to answer that. What kind of tricks could you use? Other than maybe having something of this nature out in BC, a conference or a symposium. It doesn't have to be anything as large as this, just something to get together and to share ideas and to use some of the materials that are provided here. Just, you know, stick them in the briefcases and get them to look at it. It's not that we don't want to conduct these investigations. It's not that we're shirking our responsibilities. It's just that a lot of officers don't know. A lot of investigators don't know. They know about 217.1, criminal negligence causing death, and they just don't know what the elements of the offense are. Like I said, we're programmed to look at an individual who creates an offense or commits an offense with a specific intent. So it's just changing the mindset, and they are slowly coming around. I know just from speaking to officers I know from across Canada and whatnot that they're starting to stand up and take notice and starting to delve a little bit deeper into these things.
Okay. Any comments from Michael or Robert?
Yeah, a couple. First, and I lost my train of thought. I want to talk about the length sometimes that these investigations take. And you mentioned like the statute of limitations is 2 years that charges have to be laid under the Workplace Safety and Health Act anyways. I can ask my investigators to plug far more investigations through, and we can do that. But then what kind of quality of investigations are we having? And by cutting corners and as looking at ways to plug more through and concentrating more in numbers, as as opposed to quality of the investigations that we're conducting, I've got a serious issue with that. Some of the challenges that workplace safety and health officers face when they're conducting their investigations is that they are also dealing with outside agencies. They're dealing with engineering firms, perhaps, waiting for reports on equipment that's been examined. They might be waiting for the chief medical examiner's office to provide autopsy results which can prove crucial in the investigations. Liaising with our partners with police forces as well and waiting for documentation or if they're doing additional follow-up, you have to deal with that at all as well. Not to mention, and it's not an excuse, but it's a fact that resourcing is also an issue. If I had a dime for every time I heard the expression do more with less, I'd be lying on a beach in Belize right now with a mojito in my hand. But you know what? That is also a fact that we have to work with. That being said, from a Manitoba point of view, our target for investigations is we like to have them done within a year. And that's what we're striving towards. So that way, when the year comes up, we still have an additional year if there's some tweaking, if there's some follow-up investigating that's required, and that sort of thing. Some other agencies, some other provinces might not have that. They might not be able to have that, but that's what we aim for, Manitoba.
As far as we're concerned, this is not advice that I can give that's exportable, but what we've done in the union, because I work for a union, we've formed our own union directors who are representatives for prevention. And this all criminal liability, they all have the training on C45, so the employer knows that the representatives of prevention have the training to examine these questions, which creates a pressure all the people managing that they will have to compose with the police. So they know that they will have to deal with the police. So this puts the onus on them to make sure.
For intervention.
Just a quick comment on the difficulties with how evidence is obtained and whether it's going to be able to be used, depending on whether it was obtained by the health and safety arm or by the police, where maybe the charter protections are being observed. And I think it might have been Sean who mentioned, or at least someone mentioned earlier, the Jarvis and Ling cases. And Jarvis and Ling were Supreme Court decisions. I think they came out in 2002. Where and they came out of the Canada Revenue Agency in investigations, and I'm more familiar with the area of taxation, so I kind of draw a parallel with that, where you have investigators, often accountants within the CRA, who'd be investigating taxpayers who maybe were hiding money, but they would gather all their information and then they would want to give that over to the police when they realized that we're really dealing with tax evasion, not just with someone hiding a little bit of money. And Jarvis and Ling, the Jarvis and Ling cases that came out of the Supreme Court of Canada gave us an indication of what you can and cannot use in terms of the evidence that you gather. So they used a phrase sort of, you can't cross the Rubicon. The minute that you know this is going to become a criminal in nature, you have to stop the investigation and turn it over to the criminal investigators who will gather evidence and respect the charter protections. And anything you gather before that, before people were given their rights under the charter, will not be able to be used. So what they've had to do within the CRA is make sure that they train their people who start out these investigations, who are not in the beginning criminal in nature, recognize that when the investigation is becoming criminal and stop it and turn it over. So maybe there's something there to be used in the work being done by the health and safety investigators, who, when they realize that, oh, there's more here than just someone tripped and fell at work, and it's starting to look like there might be something criminally criminal in nature, then we should stop and turn it over. And there should be discussion between the two arms so that that can happen. Thanks.
Anybody want to comment on that, or is it pretty self-explanatory? Okay. All right, well, now that we've had so much talk about beer and mojitos, I think it's time to wrap up the afternoon. And I want to thank the panel on policing. I think they were great. Thank you very much.